Hello, I'm Stephen Thrasher with the Village Voice Run and Scared blog, and I'm talking again to Metro Weekly's Chris Geidener. Hello, Chris.
Hi, Stephen.
It looks like you've had a very busy weekend again. So fill us in on everything happening around marriage and the DOJ and deportation and so on and so forth.
Oh dear.
I guess start with the case of Edith Windsor, who's a New Yorker.
Yeah. Edith Windsor had filed her lawsuit, claiming that the more than $350,000 estate tax bill that she had to pay when her wife Thea Spire died. What was basically an unconstitutional fee
Did they get legally
because
married in a
they
jurisdiction?
were legally married in Canada. And the AG opinion, now Governor Cuomo, and the courts in New York have said that that those marriages are to be recognized, and the federal government, because of the Defense of Marriage Act, rejected Edith Windsor's request to have that refund sent to her. And at that point, she teamed up with lawyers from the ACLU and from Paul Weiss, Roberta Kaplan, who had argued the New York marriage case back a few years back. And they filed a lawsuit, and she had gone forward with the lawsuit in then when the Department of Justice announced on February 23rd that it was no longer going to be defending DOMA, it was specifically in reference to Edith Windsor's case, because New York federal courts are in the Second Circuit Court of Appeals, and the Second Circuit Court of Appeals Attorney General Eric Holder said doesn't have a standard on what level of classification sexual orientation classifications like DOMA should be subject to. And because of that, that gave DOJ the opportunity to look at what standards should apply. And they determined that heightened scrutiny should apply, which makes the law presumptively unconstitutional. And so then
You
this
wrote it.
decision,
You wrote that heightened scrutiny has never been determined by the Supreme Court, right?
it's never been determined by the Supreme Court, but in most of the appellate circuits, there are 12 different geographical appellate circuits across the country. And in most of those, they've made a determination about what level should apply. But in the Second Circuit, and once the circuit has decided, that applies to the trial court judges in that circuit. But in the Second Circuit, no such decision has happened. So DOJ was in effect forced to decide what level of scrutiny it says should apply, and that's when it took the opportunity to make the determination that heightened scrutiny should apply, sent the letter to Holder, and we've been dealing over the past 6 months with the fallout from that. But what we
And
saw...
this all ties into the administration's decision to say that Section 3 of DOMA was unconstitutional, and the House is now... Go ahead.
What the determination about heightened scrutiny led to them looking at DOMA Section 3, which is the federal definition of marriage, which precluded them from recognizing Edith Windsor's claim and say that Section 3 is unconstitutional.
I see.
What they did on Friday was they actually had to come into court and say it.
Which he says the first time that's been said that way.
Well, what happened, and over the weekend I've been having some discussions with Arthur Leonard and Levi Soloway and some others about this, is that there was this filing back in July in Galinsky, and that was the first time. And Karen Galinsky is a federal court employee, and she asked the federal courts to give her equal benefits for her wife, and was denied because of DOMA. And in her case, just the procedural posture of the case was that the the House Republican leadership, this bipartisan legal advisory group, had filed a motion to dismiss her claim. And DOJ filed this 30-page brief in Karen Galinsky's case saying the motion to dismiss should not be granted. This lawsuit should be allowed to go forward. What happened?
And that was when they
procedure,
detailed all the examples of
the history of discrimination. Yeah. That was the first time after the February 23rd letter that DOJ went further than the letter itself. What they had done in some other cases was literally attached the letter to various filings in court. What they did with Galinsky's case, since the bipartisan legal advisory group led by the House Republicans had filed something in that case, they filed a full brief detailing the history of discrimination, detailing the at the federal level, at the state level, detailing the political powerlessness faced by gay and lesbian and bisexual and transgender people. They went through and detailed all of this. What they then did on Friday in Edith Windsor's case was said, not only do we think that this case should be allowed to go forward because of opposing a motion to dismiss by BLAG, but they also said that Edith Windsor's motion for summary judgment, which means it's a motion basically to avoid a trial. It says that there's no factual disputes here. We think you can decide the case on the law alone. And Edith Windsor's her lawyers had filed this motion for summary judgment, and DOJ said, we think the motion for summary judgment should be granted. So what DOJ did was a technical distinction, but I think it's significant because there's a difference between saying, we think that this case should go forward and shouldn't be dismissed, and saying, we think that this claim should be granted. That the federal government has now said, we think that this denial of Edith Windsor's tax refund, it was unconstitutionally improper, and she should be granted that refund.
So the John Boehner in the House will no doubt direct that this be fought.
They already have. They've filed a lengthy brief. They're in a significant discovery dispute over the evidence being used with Edith Windsor's lawyers, and they will have 2 weeks from Friday. So
But for the record, they are now arguing for an estate tax. They are now arguing that the government should keep $350,000.
They are actually arguing maybe that should be the PR case for the ACLU.
I think so. I think that's the way they've got to go.
Up in the state, increase taxes. But so the 19th, so it will be September 2nd. Friday, September 2nd will be the deadline for BLAG to file its reply, and that will be the last filing in this case. And then the trial court judge will have to decide whether or not she's going to hold oral arguments on this motion for summary judgment and motion to dismiss. And if she does, she'll schedule them, and if not, she'll decide it on the filings.
All right. So that was one case this weekend, and then also we had some news with the couple that was perhaps going to be broken apart in California and deported. One half of the couple.
Well, yeah, on Thursday, the Department of Homeland Security, a letter sent from Secretary Napolitano to Senate leaders. Detailed that changes in the enforcement priorities of Immigrations and Customs Enforcement with ICE in deportations would be implemented. Earlier in the summer, there was a memo from the director of ICE, John Morton, that detailed that low priority cases shouldn't receive the attention of ICE.
When they're talking about low priority cases, is this coming from a particularly LGBT focused angle or not necessarily?
It is not. I mean, it is not specifically the Morton memo itself doesn't specifically address LGBT issues, and the Napolitano letter was specifically responding to a letter sent from senators about the Dream Act, um, and so a lot of the attention has been that, but the administration officials have said that um, that same-sex couples and LGBT families are considered families for the purposes of the discretionary factors that Morton detailed in the memo, which included family ties in the United States. So they have said that same-sex couples are one of the potential beneficiaries of this new policy. And what we've seen is that saying that is enough, and just the facts of the discretionary memo that detail that family ties, community ties, having contributed to their community, that all of these things, and a lack of a criminal record, lack of a terrorist threat, lack of a criminal threat, that when you combine all of these things together, that cases, it becomes very clear that a lot of these cases that have been in the news with regards to same-sex couples are clearly not going to be the high priority cases.
And I feel like a couple of weeks ago, or maybe a little more than a week ago, you were trying to sort of quell people's immediate concern about this couple that they were going to be deported right away.
The Anthony John Mack and Bradford Wells are a couple, and now they actually raise a problem with this new system, because the new system only addresses deportation. And there are, according to the administration, there are about 300,000 people in the deportation process who would be impacted by this. But there are another like 10 million plus people who are immigrants and are of various statuses, and they effectively they are not impacted by this because they're under they're not in deportation proceedings. So this memo only relates to deportation proceedings, and so there is a question about basically, because right now, and one of the factors that Mack and Wells have talked about a lot is that they are trying very hard for him to remain in status, which means legally under the terms of his visa in the country. And remaining in status is important, obviously, because when you're later applying for visas or other immigration or a green card, the one of the factors that are considered is, have you overstayed a visa in the past? Have you been out of status? And so they want to remain in status, but this new system effectively says, we're going to have this low priority, but it's only for the people who are already out of status, already in removal proceedings, which leads to a question about what is the right thing. And this is the point that Immigration Equality has made and that Mack and Wells have made, is that what is the right thing for a couple like Mack and Wells to do? Do they overstay their visa and just hope that they don't get put in removal proceedings? And if they do, say, we're a low priority case, could you take us out of removal proceedings, and just hope at some point that DOMA's overturned and that they're able to get a green card?
And for people who are, one thing I wasn't clear about, people who are in deportation proceedings, is this strictly about their deportation, or could they potentially, the partner that's not the U.S. citizen, be able to apply for a work permit?
You can. They specifically said under this process that there will not be an automatic granting of work privileges. There will, however, be the opportunity to apply for work privileges, and and that opportunity will be reviewed on a case-by-case basis. Which it is actually that point that that some opponents of this new plan have really focused on.
Oh, really?
Yeah. I mean, for their own reasons.
So
So
it's
what we're seeing is that immigration judges who are, even though they're called immigration judges, they're not actually within the Article 3 federal court system. They're under the Department of Justice. And so they're seeing these changes and they're being impacted by them. And so we saw the Immigration Lawyers Association has reported that they had a case in California of a deportation that was closed earlier this last week. There was a case in Colorado of a lesbian couple whose asylum claim was put on. The judge put the decision on that on hold and scheduled a January hearing on a marriage-based claim, and let it be known that this immigration judge was willing to consider the lesbian couple's claim. And then over the weekend, Levi Soloway at Stop the Deportations got word of a federal judge, of an immigration judge, I'm sorry, in California, doing the same thing that the Immigration Lawyers Association had talked about, of closing deportation proceedings against another gay couple. And so, I mean, these judges are impacted by, they're seeing what the administration is doing, and they're saying we've basically been told that these cases are not a priority, and in the California case that Soloway was representing the clients, they specifically said that ICE had agreed to the motion to close the proceedings.
So, from your perspective, you've looked at this very closely from your perch. Should the president be taking heat for not coming out fully for gay marriage, or should he be taking credit for quietly and effectively undermining all these things that are keeping marriage from being a legal reality?
Well, I think both. I mean, the bottom line is that advocates looking for the president to endorse marriage equality are looking for the president to be a moral leader on that issue. But the advancements that the administration has created with this new position on DOMA over the past 6 months is a remarkable technical advancement and a great use of sort of the machinery of government, and a great use of his discretion as the executive branch in, for example, in this deportation situation, of looking at the limited resources of the government and deciding that everybody agrees that there are more people here not in status, that are out of status, that could be subject to deportation than the government could ever address. Mm-hmm. And so to make the decision that the smart way of addressing this is to deal with those people who are most likely to cause a danger I mean, it's both smart politics, and I think the administration has concluded smart policy, and it's a policy that advocates are clearly happy about.
Well, thank you very much. As always, it's interesting talking to you. This case seems a lot more nuanced. This issue seems a lot more nuanced than it often gets portrayed. One last question before we go. I was supposed to talk to our old friend, Lieutenant Dan Choi, this weekend. And then I found out he's been arrested yet again in the White House. Any sign of him over the weekend?
I honestly, when you told me about it, was the first I'd heard of it.
I heard that they're actually... he was arrested with a group of about 70 people, and I haven't found out whether they've been released or not, but America Blog was saying that they were being detained for at least 3 days, which I understand is highly unusual for protests in and around the Capitol. So I will try to find out more about that. But usually when he's been in jail there, he's been sprung within a day, so I'm surprised it's so long.
Well, I mean, the weekend is a problem. I mean, yeah. You can also conveniently plan your arrest to make it. I mean, you need to remember, I mean, one, I mean, a lot of this it is about getting coverage, and I mean, Dan has been very, very successful at that, and so I mean, you can certainly, I mean, it is difficult for, I mean, courts are not in session over the weekend. You can pull a judge out if you have an emergency need, but I mean, there's no court hearings over the weekend. So they're if they were arrested on Friday
Friday.
afternoon, it's entirely possible that the next arraignment time isn't till Monday morning.
Well, great. Well, thank you so much. Great talking
Thanks a
to you as
lot, Stephen.
always. I will talk to you
Good
soon.
luck this with your week.
Thank you. Bye bye.
Bye bye.